Welcome back. Shh. Shh. Thank you. Welcome back. Most of you watched the makeup class. About 20 of you didn't. That's disappointing. It's a freebie. You could have just watched the video and gotten credit for it. It will be on the exam, so hope you learn it now. It's disappointing. You should all have watched the makeup video. You had a week to do it. You didn't do it. All right. Yeah, it's disappointing. Questions on material from last class. Last class we covered easements. We introduced the concept of easements by necessity. Any questions on that? No? OK, let's do a poll question to start to refresh our memories from last week. All right, so here's your question. Adam, who owns wet acre and dry acre, conveys wet acre to Betsy. But Adam retains the right to use the lake on wet acre. Okay? So here's your question. What is the dominant estate? Huh? Just answer the question. Adam, Betsy, wet acre, dry acre, or none of the above? Okay. Adam, Betsy, wet acre, and dry acre, or none of the above? Okay. All right. So where am I? And remember? Okay. Let's see. What's your name?
Morgan.
Morgan. All right. I'll start with you, Morgan. I'm going that way?
Yes.
Okay. All right, Morgan. Let me ask you a question. What does it mean to be the dominant estate?
So it's the estate that's benefiting from the right to use the other.
Okay. The estate that's benefiting. What's the opposite of the dominant estate?
Subservient.
Okay. Very good. All right. So Natalie, what's the answer to this question?
Well, would it be wet acre? Because
Why do you think it's wet acre?
is it because? No, sorry. It's wet acre is subservient because it's giving to the
Okay. So what's the dominant estate?
I guess that's
Well, let's ask one question to start, Natalie. Is a dominant estate referring to a person or a piece of property?
he's like property.
So could it be Adam or Betsy?
But dry acre is not. I guess I'm confused because Adam conveyed only wet acre to Betsy, not dry acre. So
What do you call this kind of easement, Natalie? Remember there are two kinds of easements. What do you call this kind of easement? What's an easement appertenant?
no, sorry, it's a. Yeah, it is because it requires a dominant and
What are the two kinds of easements, Natalie?
easement and gross and easement appertenant.
Okay. Tell me, what's an easement appertenant?
It gives the easement owners, not the land, the right to make some specific use of land they do not own.
Okay.
It's not right to whoever owns a parcel of land.
So let's look at this question here. What kind of easement's at issue here? An easement appertenant or an easement in gross? almost there.
Easement gross.
Why is easement and gross?
Because he's giving her land too, not just the right to use it.
And who has the benefit?
Adam, because he can.
Does the owner of a piece of land have the benefit?
Sorry, she.
Who gets the benefit here in this question?
Well, Adam, because he gets to use the water, right?
Right. Is the benefit assigned to the owner of a piece of land?
It can be, right?
What does it say here? Who retains the benefit?
Adam.
Okay. And what do you call it when you have an easement that benefits a person, not a piece of land?
The ingross.
Aha. Okay, so now finish it up. You're almost done. With an easement in gross, is there a dominant estate?
No.
No. So what's the answer here? None of the above. That's the answer. Thank you. Most of you got it wrong. This is why, thank you, Natalie, very good. This is why you have to walk through these questions carefully and determine what kind of easement you're dealing with. If you're dealing with an easement in gross, the benefit belongs to a person, not a dominant estate. Therefore, there is no dominant estate. With an easement in gross, there is only a servient estate. Mackenzie, what's a servient estate here in this question?
Pardon?
What's the servient estate here in this question? In this question, what's a servient estate?
Would it be what acre?
What's
It'd be
a servient estate mean?
serving estate, the one that is serving the.
Oh, no, you're not asking me. What's a servient estate? Check your notes. It was only a week ago. It wasn't that long ago, guys. What's a servient estate? Matt, what's a servient estate?
The estate that's has one of the bundles of sticks, one of the sticks missing from the bundles of sticks.
Okay.
So I'm going to say it's wood acre since it's lost the right to exclude Adam. So it's subservient to Adam.
Okay. In this question, right, which estate is being burdened? Right? Which estate's being burdened? The estate that's being burdened is wet acre, because wet acre can allow someone come along and come on board and take water. So we say that wet acre is servient, right? But there is no dominant estate because there's an easement in gross. The benefit belongs to Adam wherever Adam goes. So at the present moment, Adam owns dry acre. Right? Adam owns dry acre. What if Adam sells dry acre? He can still come onto wet acre to get water. Right? He retains that benefit. Right? So we say with an easement in gross, you have a servient estate, which is wet acre here, but you don't have a dominant estate. Now, one second, Steve, I just want to look at the results. A couple of you put Adam or Betsy. I don't know what to do with that. Those are just, that's not correct, right? A estate refers to a piece of property, not a name. A handful of you, about 5 of you, put wet acre. That answer inverts what it means to be dominant, what it means to be servient, right? Dominant is the one that's benefiting, not the one that's being burdened. The answer I expected most wrong would be D, right? Because you'll say, oh, dry acre. But you have to recognize what kind of easement's at issue. If you don't do that, you'll get the question wrong. So this one, basically only a third of you got it right. So if you put E, good job, you caught it. Otherwise, you need to think about it more carefully. Yes, sir?
I just have a question about easements in general.
Yeah.
From my general understanding up to this point, taking this class, I always thought an easement was maybe you could use the road that goes through a property. Or
That's one type of an easement, but it's not the only type of easement. You can do easements for a lot of different things.
So when you said that Adam would retain the easement for whatever period of time, his life or whatever it is, he can access that property to get to the water. Does that mean he can enter from any which direction to get to it, or just the most direct route?
They would probably define the point of entry. Generally, when you have black acre and white acre right next to each other, you can cross wherever. But let's say you have to go over some intermediary property, might be problematic, right? Let's say to get to wet acre, you have to cross over like 3 pieces of land. You may need permission from those places as well if wet acre is not, subject to a public road. But you'd have to contract for that. All right, everyone understand that question, why the answer here is E. It's actually very important. I didn't mean to torment Natalie for so long, but I suspect a lot of people have the exact same thought process, which I want to sort of tease it out. Okay? All right, everyone with me? Good? Okay, very good, thank you. All right, let's move on to today's material, which focuses on different ways of getting an easement, right? Last class, we talked about a couple ways of getting an easement. The first was, how do you actually convey an easement? And the answer was, at common law, it was sort of complicated. To convey an easement at common law, you have to do this. You have to basically sell the piece of land with the easement attached to it, right? You couldn't just say, OK, here, Josh, I'm giving you an easement, right? You can't do that. You have to basically sell Blackacre with the easement attached to it. And if you wanted to benefit a third party, you would actually have to convey the land to that third party and then convey it back with the easement attached to it. That's the Church of Christ Scientist case from California. That was the common law rule. But we know that California does what California does. They reverse the common law rules. So the modern approach is that it's not necessary to do this sort of intermediary purchase. All you need to do is simply convey the easement as a standalone stick in the bundle, so to speak. All right, everyone okay with that? The second case we did last class concerned oral, right? What might be called a license, right? When you give an oral permission. And there might be some cases in which oral permission cannot be revoked. And that's based on what's known as estoppel, or maybe reliance, right? Where there's some sort of fairness interest that says you don't give up, right? You can't give up this easement because it's so important to you. Okay. We're going to do 2 issues today, 2 other ways of acquiring easements for class for today. One of which is what's called prescription. And let me just write it because people always spell this word wrong. Prescription, right? Of course I spelled it wrong, right? Prescription, we discussed before, is sort of like adverse possession, but for easements, right? If I sit in a house for 10 years and I have the right state of mind and the owner has a notice about it, I will acquire fee simple to Blackacre. Prescription works a little bit differently. With prescription, you're not trying to acquire fee simple to Blackacre. You're trying to acquire the right to cross Blackacre. So if I walk across Blackacre every single day for 10 years and I use the exact same path, and the owner knows I'm doing this and I have the right state of mind, I acquire an easement by prescription to cross Blackacre. Right? I don't own Blackacre. I can't build a house there. But what I have obtained the right to do is to cross over it. We did a case like this the first week of the semester with von Valkenburg versus Lutz, if you recall, where the guy would cross over the yard every single day to get to the road for however many decades. And he actually would have acquired a prescriptive easement. That's different from obtaining fee simple. And I just I'm repeating this point because I know you're going to screw it up in the exam. Do not confuse adverse possession and prescription, right? You do not obtain an easement by adverse possession, right? Don't use the word adverse possession when we're talking about easements. What will screw you up is that courts will sometimes use the phrases interchangeably, right? Courts will say prescription when they mean adverse possession, and they'll say adverse possession when they mean prescription. In your notes, keep them separate. For fee simple, you want to acquire the land as adverse possession. For an easement to cross, you want prescription. Just if you keep it straight in your notes, I'll be happy. But I don't want you to mess up your terminology. Stuff is hard enough without screwing up the terminology. Okay? So any questions on prescription? Oh, yes, sir.
In the text, is prior use and prescription synonymous?
I'm going to dodge your question because in some cases they're treated similar. The next topic is easement by implication can blur what prior use is, right? For my purposes, prescription is very specific. It means you have a hostile state of mind and you're doing something for a certain prescribed period of time, right? There's a limitation period, 5 years, 10 years, whatever it is. The second topic, which Tyler is getting at, isn't so rigid, and it's a little more flexible how you can acquire it. And that second topic is what's sometimes called easement by implication, right? Or a related idea is easement by necessity, right? This concept is a lot harder because it involves a court deciding, should we create an easement where the parties didn't contract to one, right? If you can get an easement by prescription, you do that. That's easy to satisfy, right? That doesn't involve any balancing of hardships. That simply asks, do you have the right state of mind? Did you do it for the requisite number of years, right? Adverse possession, prescription, they're not easy questions, but the judges don't have discretion, right? If you have the right state of mind, owner had notice, and you have the continuity for the requisite number of years, you get it, right? It's not like a judge can say, well, you know, Mr. Robinson was in the house for 10 years, but I don't think it's fair, so he doesn't get it. No, no, no. With adverse possession, it's a statutory creature, right? The statute says if you do the right thing for X years, you get Blackacre, right? If you cross over the land for 10 years, you get the easement, right? That's easy. But the second topic is a little bit more fluffy. And what do I mean by fluffy? It's based on a judge's sense of equity. You know that word? Fairness. Necessity is a word we'll use a lot today. Is it actually necessary? The judges decide, do the parties intend to have this sort of easement, right? All the inquiries today, especially in the Texas case, is a judge deciding, is this unfair, right? Is this really necessary? And you know, one of my least favorite words in the English language is fair. I hate it. I don't know what it means. But the judges have to decide it. So you can separate the prescription cases from these sort of equitable cases based on, is there discretion, right? Or the judge has said, okay, 10 years, you're good, versus, okay, let me think about it. Is this really necessary? And you see that the courts sort of go in different directions on this front. Okay, any questions in that general frame? Okay. All right, so I want to start off with the topic of implied easements. Okay, implied easements. Is that Ethan? Ethan, what does the phrase implied mean as a general matter? Not in this, but as implied. What does implied mean?
This is kind of it's like this is something that the two parties just kind of silently agree on.
Okay, well, what's the opposite of implied, right? If you have an implied understanding, what's the opposite of implied?
Express.
Yes, and what does express mean?
That the parties just like they may actually like write it down.
Yeah, written. Yeah, thank you, Ethan. Exactly, right? Generally, in contracts and in property, we prefer express agreements, right? This is 101, right? Basic. You want an express agreement. It's written down. It's in writing, right? It's in writing. But what happens if people have some sort of understanding that is not in writing? This is what gives rise to what's called an implied easement. And maybe they didn't put the easement in writing, so therefore it's not a written easement. But the court can say, but there was an implied easement. And the court may say, we're going to enforce this implied easement. Now, the difficulty of enforcing unwritten contracts is you don't know what the parties actually intended. Right? The reason why the statute of frauds is so important is it's not just to torment you, but it's actually established with written proof what the parties' intentions were. If you're relying on unwritten assumptions, well, things can change, right? Maybe party A says, oh, I had this in mind. And then party B says, oh, I had that in mind, right? How's a judge to unravel that sort of debate? Judge has to make a judgment on values, right? I believe him or I don't believe her, whatever it happens to be. So the court explains that there are two primary kinds of implied easements. Is that Morgan?
Yes.
Morgan, what's a quasi easement?
Where the portion of the tract is divided and the easement is applied basis on the continuity requirement that they've been doing it for a certain amount of years.
You did what I said not to do. You conflated, I'm not mad at you, but it's predictable, right? You conflated adverse possession prescription with an implied quasi easement because you said for a certain number of years, right? That's the limitation period is one of the characteristics of prescription. 10 years, 5 years, whatever it is. But Morgan, quasi easements are different. They're similar, but they're different. How is a quasi easement different from a prescription? Well, let me put it this way. Is a quasi easement fixed by statute? Has to be X years. Okay. But then how do you know if a quasi easement exists? So yeah, okay, so I think you're on the right track. Now, Bina, let me ask you a question, right? If you had a choice, right, you're a litigant, what would you rather go into court with? Arguing that you have prescription or arguing that you have a quasi easement? What would you prefer if you were going to court?
Quasi.
Okay, why quasi?
Because
Which one is more certain, right? Which one are you more certain to get? A prescription easement or an easement, a quasi easement? Which one's like you more certain to get?
I'm still confused about like the quasi.
This question is designed to relieve that confusion. Let's say, let me ask you this. Let's say you've been on this land for 10 years. You've been crossing it every day for 10 years, right? You've had the right state of mind and the owner's aware of it. What's your lead argument in your brief? Do you argue lead prescription or do you argue lead argument by quasi easement?
Prescription.
Why?
Because over a passage of time, been doing it, there's no interruption.
Okay, good. And is there any way the court can deny you if you've been there, if you're doing it for 10 years? Does the court have discretion?
I mean, if there's any other way, or
No, so you're confusing them again, right? You're confusing it. Elizabeth, if you've been crossing for 10 years and you've been doing it the right state of mind, does the court have any discretion about prescription?
No, because you're satisfying the requirements.
You satisfy the statute. It's statutory, my friends, right? If you satisfy the statute, you get automatically. Now, Bina, I want to come back to you because you made a good point. You talk about, is it necessary, this or that? When do courts consider necessity? For prescription or for a quasi easement?
any easement.
Sorry?
Easement?
Which one? Prescription or quasi easement? When do courts consider necessity? For prescription or for quasi easements?
My issue is that I don't understand like the quasi easement, but
Do the courts consider necessity for prescription?
no.
Is that one of the factors, one of the four factors? So when do they consider it?
I guess for the quasi easement.
Very good, yes. Let me explain this now clearly. I think I got what I wanted out of you too. Thank you. It's a tag team, a group team effort, right? You need to distinguish prescription and quasi easements. With prescription, it's the same four factors as adverse possession. Open, notorious, claim of right, continuous, right? The same four factors. Necessity and fairness do not factor in to a discussion of quasi easement. I'm sorry, to a discussion of prescription. I did it, right? Necessity and fairness does not factor into prescription. If you get to 10 years, you're good. Now, if you're a litigant and you have been there for 10 years, of course you're going to argue prescription. What if you've been there for 9 years? Right? What if you've been crossing the land for 9 years and you've not met the 10-year threshold? At that point, Kayla, what do you have to argue?
Sorry, what?
If you've only been there for 9 years and not 10 years, you can't argue prescription. What do you have to argue? Bingo. The reason why you argue a quasi easement or implied easement is because you don't meet the requirements of prescription. Let's say it again. The reason why you go to court and you argue for an implied or quasi easement is because you don't meet the requirements of prescription. If you're a litigant and you can be, say, 10 years, you go 10 years, you go prescription. But if you can't meet that, it's your backup. You're basically asking the court for fairness, for equity, right? Right? You're saying, court, I need an implied easement for fairness, right? You need to imply one. If you make 10 years, you don't need to make these requests. You can just say, judge, 10 years, I'm done. Give me my easement, right? By prescription. But if you can't get there, you say, Judge, in the alternative, please, Your Honor, mercy, right? Fairness, necessity, prior use, right? Give it to me based on these other things. Maybe you win, maybe you lose. Think of the Texas case, right? But you at least have a shot. I want to understand that distinction. It's so easy to mess up because people confuse prescription and implied easements every single semester. I can't tell you enough and you're still going to do it. I'm going to try. Okay? Keep in mind, now the way I can get this in the exam is I won't ask, is there an implied easement or is there a quasi easement? I'll give you a fact pattern, and you'll have to decide, does the person meet the requirements for prescription? If not, then you have to talk about implied easements, right? I won't ask you what kind of easement is it. I'll give you facts. You have to pick out what the standards are met. Yeah, I'll just say, I'll say something like, what is John's strongest claim to Blackacre? And you'll say, he gained an easement by prescription. Or you'll say, well, he didn't meet the requirements of prescription. He wasn't there for 10 years, but he might have an implied easement. Good. That's a good answer. Right? And I won't tell you which one it is, but it'll be one of them. And you have to then figure out. Okay? Everyone with me? All right. Is that anything at hand? Okay. So, Elizabeth, let me go back to you. What, again, is a quasi easement? How does the book define it? What does that mean? Yeah. Okay, so Elizabeth, let me just ask this question one more time. If you've been using the property for so long, why don't you just claim adverse possession? Yes. Everyone heard what you said? That's exactly the right thought, right? You've been using the property for so long, you might be able to get an easement implied, a quasi easement, but you've not been using it long enough to get adverse possession. Right? Think of the 9-year hypothetical, right? If you've been there for 9 years, you argue quasi, prior use. That's your question, right? If you've been there for 10, then you can actually argue you've got it by prescription. Everyone understand that point, right? Yes, ma'am.
So, I mean, I just think of the case where the attorney, like, are you?
Oh, von Valkenburg, the first week of the semester.
Just like, I mean, like, I guess
He messed them up. He confused them.
messed it up really
Yes.
bad.
Say it one more time. I will make sure everyone heard you. You're exactly right.
I guess like now that we're done with anything about
Yes. The lawyer in the first week of class, von Valkenburg, the very first week of class, right? He argued in court that his client obtained an easement by prescription when he should have argued adverse possession. But he could have also argued an easement by necessity as well, even if they don't meet the requirements. So even lawyers mess this up. And I didn't make a big fuss at the time, but I think the court used some loose language there also to describe what I was talking about. Which is why I like the von Valkenburg case, but it requires knowledge of easements, which you just didn't get to yet. So now it completes the picture a little bit, right?
Yeah, because I was like, well, I mean, like,
Look, lawyers make mistakes, right? I mean, and this is why there was a malpractice action also against that lawyer, right? You know, if you go to court and you argue for A when you shouldn't argue for B, your client can sue you for malpractice. It's not like a joke, right? That's like a thing you should all be aware of. You know, you got to do a good job, but if you don't, you can be suspended. You can lose your license. Or things that happen.
but for in that case, sorry, like it was for so long though, so it's like I don't.
Well, he would not have needed an implied easement. The problem in that case was he asked for prescriptions to have adverse possession. Yeah, Stephen?
Occasionally you hear about these people that have their garage built a few feet over on someone else's property or over on an easement that's granted to the state or whatever, or the city for access to pipelines or something like that. How are they not able to, I mean, or would they be able to claim an easement by necessity or an implied easement because no one stopped them now and the house has been there 20 years?
Well, okay, so there are two questions, right? One, what if your sidewalk goes over your neighbor's property, right? We did a case like that from New Jersey, right? Manila versus Gorski. Remember they built the staircase over. I think your question, though, is what happens if you are trespassing on government property? right? If there's some sort of government easement and you're intruding upon it. Generally, you cannot claim prescription against the state, right? Imagine there's a public park, right? And people sleep there every single night for a decade. I mean, it happens. Look, I mean, just go to their public parks. People basically live there. The general rule is you cannot claim adverse possession against the state. But, and here's a big but, there was a decision like a week ago from the Pennsylvania Supreme Court that involved an adverse possession claim against the city, not the state, the city. And there was this guy who was basically, he took a public park and turned it into a garden. And he raised vegetables in there for, I think, like 20 years or something, right? And after all, the city said, okay, this is now a beautiful garden, we'd like to take it over. And the guy actually claimed prescription against the city. Again, not the state, the city. And the Pennsylvania Supreme Court actually held that you can claim prescription against the city. You can claim adverse possession against the city. So the city actually lost that property because they knew he was there. They did nothing to evict him. That was a rare decision. I actually sent that link to the opinion to the casebook editor last night. I was like, oh, this is relevant because I remembered when I was prepping for class. So the short answer is you usually can't. There's a note in the book I mentioned about Rockefeller Center, where there's part of Rockefeller Center that's actually a public sidewalk. And then every year for a day they shut it down to prevent any prescription claims. Imagine you walk across 30 Rock every day for a decade. I own 30 Rock, right? I have a stick in the bundle. They're worth billions of dollars. No more. They shut down the sidewalk. But good question. Okay. So a quasi-easement is a type of easement by necessity. I'm sorry. A quasi-easement is a type of implied easement based on prior use. If you've been using property in a certain way for a very long time, the court, as a matter of equity, can say there's a quasi-easement. Again, it's not long enough to meet adverse possession. I did it. Prescription. I did it. Yeah. Yeah. It's not long enough. Make sure my notes are correct. To meet the requirement of prescription. You're not there for 10 years. You're there for 9. But you have some sort of equitable claim to the land to keep using it that way. In other words, they imply the easement from your prior usage, based on custom, if you will. If you want to use a really nerdy example, Justice Frankfurter's concurrence in Youngstown, you have a long, systematic, unbroken practice, which no one's challenged, and you keep using it. Sorry. I taught Youngstown this morning. Yeah, go ahead.
Is time the only factor that a quasi-easement covers? Is that just the example you gave?
I'm using it because it's an easy example. But it might also be on investing money, for example, right? Think of the case last week where there was a road and the guy made improvements on the road. That may also factor into the quasi-easement, right? Investing money is not a factor for adverse possession prescription. It doesn't matter how much you invest. You could just be like Mr. Robinson sitting on a chair for a decade, and that'll do it. But the courts with quasi-easement do favor improving and investing upon the land.
One more question that just popped up. Can you use any time in which you have a license to the property, like if you're a tenant under a landlord?
You can't. Are you saying can you imply an easement if you're there on a license?
Yeah. So say if you have use of the land, and then if you
Yeah.
rent the land.
Yeah, I see your point.
And then
Yeah,
you
that's like the case we had last week, the one with the road, right? The West Virginia case, because he was there with permission, and because he invested money, they said that they can't revoke the license. At that point, I don't think it's a. I don't think you would call it a quasi easement. I think you'd say it's a license that could not be revoked. It's an irrevocable license. I think that's how you would characterize it. So it's a little bit different. Yes, sir, Matt.
Would you also use quasi-easement if you don't meet the assertion of right portion of prescription as well?
The claim of right, you mean?
Yes, the claim.
You don't need to show that.
Okay. Oh,
Right. You do not with quasi easements. You do not need the 4 elements of prescription. You don't need to touch them.
That's what I meant with prescription. You would any of those 4 elements not.
Your
met,
state of
prior to
mind.
quasi.
Your state of mind is irrelevant, right? For a quasi easement.
Okay. So if you don't meet any of those 4 elements, you
Doesn't matter.
quasi.
Right, and which is exactly why if you can meet those 4 elements, you do the 4 elements. But this is if you don't meet those 4 elements, you do the quasi. Yeah. Again, don't confuse the terminology. I did it a minute ago. I'm sorry. I'm guilty as charged. But be better than me. Don't make my errors. because they're very easy to trip up. Whoever caught me, thank you. Okay. The second type of implied easement is a little bit different, and it's the subject of our next case. It's called an easement by necessity. Dakota, what does that mean, easement by necessity?
It's the courts basically find that the easement is necessary to enjoy the use of the land or the property. So like usually it applies when somebody landlocks themselves, where they
Yeah.
can't. I mean, they have to like cross, and so it's basically necessary for them to have the easement there to get out of the property to the road or something like that.
Okay, very good. Thank you, Dakota. That's correct. An easement by necessity is rare. The courts don't like these, right? It's not based on a prior use. Instead, something happened that you can no longer enjoy the land. So imagine, using the example today, someone builds a dam which floods your property, which you can't cross, and you're landlocked, right? Those are cases where something suddenly happens which puts everyone in a bad stage, and the court may then imply an easement. But let's say it's a little bit different. Let's say that you buy a piece of land, and it's bordering water on all three sides, and then someone buys the land next door and doesn't let you cross anymore, right? Your only way of getting to the road was by crossing this land. Someone bought it and won't let you cross anymore. The court may require an easement by necessity. Or the court might be tough and say, you know what? You can buy a helicopter. You can buy a boat. You can go around, right? Let's say you have a piece of property next to a mountain. You can climb the mountain, right? The standard in Texas, at least, and in some other states, is what's called strict necessity, right? Strict necessity. Is it absolutely necessary, right? Do you really need this easement, or can we go around it? Most jurisdictions apply what's called a reasonable standard, a reasonable necessity standard, where, is it reasonable to have this easement? Yes, okay, you get it. But you'll see in this case, it's pretty darn strict, at least in the Texas standard. I looked this case up. It's got a yellow flag, but for some other reasons, I think this is still good law as far as I can tell. Okay. Any questions in the standard? Okay. Alexis, you want to give me the facts, please, in our first case, Othen versus Rosier. And the facts are a little bit tricky, but we'll walk through them.
So, the land of both parties in this case was owned by Hill.
Good.
And then, so first Hill conveyed a piece of land to Rosier.
Okay. I'm going to interrupt you, but I'll come back to you in a minute, okay? Okay. So we have, and this is an illustration the authors of the book put on their website, which I like better than the one in your books. It's colorful. But you have this plot of land. It's called the Tone Survey. Survey just describes plot of land. I think Tone was the guy's name, I'm guessing. It's bounded by roads, Fish Creek Road, Beltline Road, Duncanville Road. So it's this huge plot of land. I mean, I have a picture below it. I mean, this is what it looks like today. It's just ginormous. It's a huge plot of land. And it's only partially developed today. Okay. So the first transaction was in 1896. And Hill sold to Rosier. Rosier? I don't know. Hill sold to Rosier this first 100-acre plot of land. Okay, so Alexis, let me ask you just one question here, right? Does Rosier have any problems in 1896 by buying this piece of land? Is there any reason why, we should be worried about selling this piece of land?
The road that was, yeah.
Well, just you're jumping a little bit ahead, but just in 1896, yeah. Right? When Rosier bought this first plot of land, is there any problem there? Okay. All right. Now, Alexis, what's the next transaction we should be thinking about?
Then Hill conveyed another piece of land to Othen.
Okay. In what year?
In 1900.
Not quite yet.
Oh, wait. Oh, 1896.
Okay, very good. Thank you. Okay. And there was another one just 2 years later in 99. Okay. So the first transaction, again, is the blue square, right? Rosier sells 100 acres in 1896. And then the next year, Othen purchases 2 plots of land. In 1897, he buys these 60 acres. And in 1899, he buys these 53 acres. Okay, and it's actually not to Othen, but it's Othen's predecessor. But I'm just going to say Othen to make it easier for you. It doesn't really matter. Oh, by the way, the word mean, M-E-S-N-E, it's not mesne. I know you want to say mesne, but just it's mean. It means intermediary. That's all that means. So, oh boy. So Hill sold it to Othen's predecessor. We don't care the predecessor. It's not important here. Okay. So is that Courtney? So Courtney, so far so good, right? You're Mr. Othen, or you're his predecessor, and you buy these 2 plots of land. Is there any problem by buying these 2 plots of land in 1897 and 99? Is there a problem that you might be aware of?
Not at that time.
Why do you say that? Would Othen have been able to, and again, it wasn't Othen, but I'm saying Othen to make it easier. Was Othen able to cross over to the Beltline Road at that point?
Yes, because he had permission.
Who did he? Who owned the green? Who owned the green at that point? Who owned all the green?
The state, I assume?
No. Who was selling up this land?
Hill did.
Hill. So Court, let me ask you the question again. In order for Othen to get to this road over here, which land would we have to cross over?
Rosier's.
Or
Hills.
or Hill? Okay. Did he have permission to cross either of those?
No.
So we have a problem here, Josh. What's the problem? When Othen bought these 2 plots of land, what should he have been like, thinking about? It's like, uh-oh.
Access to the road.
Yeah. Did he bargain in his deed for any sort of access to the road? Did he, when he bought this land from Hill, and again, it wasn't him, but just when Othen bought the land from Hill, did he retain an easement to cross over Blackacre to get to the road? So then what happened, Josh? What happened after some years passed?
I
What-
guess Hill sold the 16.31 acres.
Good.
To
Yeah.
Rosier.
Yeah, exactly. And then what happened? What happened more recently?
There was like flooding, and so they built a levee. And
Okay.
it restricted Othen's access to the road.
So how was the only way for him to get across to the road?
It was just that yellow lane there.
Yeah. Right. So what happened was at some point they built a dam, right, to prevent some flooding. And the effect of the flooding was to make the land where Othen crossed muddy. He could only cross on horseback. Yeah, it's kind of funny, but Texas, right? At that point, Othen sued to enjoin Rosier from interfering with his use to cross the land. Now, Javier, let me ask you a question, please. Could Othen have claimed prescription?
No,
Why do you say no?
hadn't enough time.
I think that's probably right. I don't think he met all 4 elements anyway, but at a minimum, I don't think he had a requisite amount of time. All right, so again, if you can meet prescription, you claim a prescriptive easement. He could not do that, Javier. So instead, what did he go to court and argue?
He said he had an easement of necessity.
Easement by necessity. He was seeking an implied easement, right, to cross over this yellow line, right? He was seeking an implied easement, and specifically an easement by necessity. Okay? So, Lauren, I want you to walk me through the court's analysis of how they decide whether an easement by necessity is appropriate.
Didn't they look to see if there was any other way he could have gone to his property?
Okay, well, how does, just take one step back, how does the Supreme Court of Texas, which is now your Supreme Court, define easement by necessity? What are they looking for? What's that phrase they use? How does the Texas Supreme Court understand strictly necessary? Damn it. How does the court understand, she didn't hear it, easement by necessity? How necessary? Yeah, there it is. Okay, I said it. I have this awful habit where I say what I'm thinking. It's a terrible idea, I know. But I often say out loud what's in my head, and I give students answers. It's very bad. But yes. So Lauren, how does the court understand strictly necessary? How does the court understand that phrase? Just give me one more thing. Lauren, let me ask you this one, right? When Othen purchased this land in 1897, 1899, was he landlocked? Was there another way he could have gotten to this road over here? Oh, could he? You're his lawyer, right? How could he have gotten to the road? He's over here. He's the pink lot, right? How could he have gotten to the road? Instead of crossing over the light blue one, how else could he have gotten to the road? Well, the yellow is the pathway. How else, other than going over the yellow, how else could he have gotten to the road? Yeah. He could have purchased an easement from Hill, right? He could have obtained a right-of-way from Hill. There are other ways to get to the road beyond the yellow line, right? So even though he was, I guess, technically landlocked, he wasn't really, because there were other ways he could have gotten to the road. And what the Texas Supreme Court says is necessary means strictly necessary, absolutely necessary. Because there are other ways of getting to the main road, he would not have needed this easement across the 100-acre lot back in 1896. Yes, Matt?
So if both Hill and Rosier had been spiteful, do you think it might have come out differently? As far as like, you can't give them enough money.
I don't think the intent matters, right?
Okay.
Because let me put it this way. Right? Othen wanted an easement here. Why not an easement like that?
Wouldn't that be Hill's, with both Hill and?
Right. In other words, you're asking for an easement on one property over the other. Why should the court give you this one, right? When you bought this land, you should have known that you were stuck, and you could have then purchased an easement at the time. What the strictly necessary standard means is we're not going to help you unless you're like upon a mountain or something, right?
Okay.
We're like, something changed that put you in a really bad position. But if you walked into this and you had other options and you did not exercise those options, don't ask the court for help. Don't come to the court when you could have bought this yourself to fix your situation off.
Okay. Kind of like implied assumption of the risk sort of thing.
Yeah, I guess. But again, it wasn't even Othen. Othen bought from someone else. But it's even worse. When Othen bought this, he should have known there were no easements from him. He bought the land anyway from his predecessor. Everyone understand? So here the court holds strictly necessary means absolutely essential, right? And the court's not going to imply an easement, I did it, where the parties can negotiate it for one. Yes?
Can you explain what the court meant by that necessity existed at the time of severance of the two estates?
Okay, great. Okay, so Natalie, at the time that these lots were purchased in 1899 and 1897, right, when it was severed, when the green lot was severed apart, was this yellow line necessary, strictly necessary? No. So because the easement was not necessary in 1899 when the lot was severed, the court will make it necessary now. Does that make sense?
Yeah.
Yes?
Yeah, but what if something happens later?
Like what?
If something, like with a levy?
Well, even though the levee broke, that was still dependent on what existed at the time the land was severed. It really doesn't matter. I think what the court's saying is if you walk into a piece of property knowing that you might get landlocked in the future, it's too damn bad. You should have thought of that, right? If your entire existence depended on basically trespassing over someone's land, we're not going to bail you out.
So what would be a situation where they would?
It's hard to think of one, right? I think it would have to be a situation where you bought the land and something happened. You know, maybe there was like an earthquake. I don't know, right? Maybe there was a hurricane that washed away a bridge, right? Maybe there was like some sort of a natural disaster where the land, you know, sunk into the earth and you couldn't cross, you know, like a sinkhole or something. I don't know. But the Texas standard basically means you're going to lose.
And then if like say like it was like a bridge was washed away, they would allow the easement by necessity, but only for the
Yes, and that's an important point. Thank you for raising that, Morgan. With an easement by necessity, they're temporary. It's not permanent, right? Maybe there's some natural disaster and a bridge washes away, and the court implies an easement so long as it takes to build a new bridge, right? And when the necessity disappears, so does the easement, right? The easement exists only so long as the exigency, the emergency exists. Okay, good question. I saw a hand over here somewhere. I thought I did. Okay, everyone with me? All right. The Texas standard is very tough, and I think it's still good law. Okay. All right. So any questions on the Texas case, Othen? Not many Texas cases in this class, unfortunately. This is one of the few. Yeah, the cute little story at the end. 40 years later, Othen's daughter bumped into Juanita Rosier at a cotton gin, and they fell into each other's arms and made up. Okay, that's kind of sweet. And they tore down the Othen house in 1988. Okay. It's kind of cute, I guess. I don't know. The stuff you decide to put in the book, yeah, it's there. Okay. Questions on Othen? I thought of one example. What happens if the only way of getting to the road is by either going down a cliff or building a road for like $1 million, right? You could build a road down the cliff. Well, the court might say, okay, build the road, rather than having to give an easement across someone else's land. Sometimes the courts are very stringent. Let's do an example. On page 793. Yeah, where is it? This example right here. I think it's question number. No, it's question 3. Yeah, it's question 3. Yeah, it's at the bottom of the page. Okay. Who's next? Jasmine, I think you're next. You want to read this from question number 3 for me, please? It's with this diagram. Okay, just pause for 1 second. Thank you. Okay, so A owns 1 through 5. Okay, he's the common owner for all these things. Is there any problem, Jasmine, that A owns lot number 5 here? I'm sorry? A owns all 5 of the lots. Is there any problem that A owns lot number 5? I can't hear you. Why not? Yeah, you can't trespass on yourself, right? 5 is landlocked, to be sure, but there's not a problem. You can't trespass on yourself, right? That's not a thing. You can't do that. Okay, go on. Keep reading, Jasmine. Thank you.
All 5 lots have previously been owned by O as a single tract. A purchased each lot from O in a separate transaction. Lot A first. Lot
Okay, now this becomes significant, right? He buys number 1, 2, 3, 4, and then 5, right? No problem, right, Jasmine? He owns all of them. He can cross across it. All right, now go on.
Lots 1 and 2 are bounded by a public road on the north. Lots 3 and 4 are bounded by a public road on the south. Lot 5 has no access to the public road except through one of the other 4 lots.
Okay, now it gets a little trickier, right? All right, okay, do you want to keep reading?
Yeah, A dies intestate.
Okay, which means he has no will. Okay, go on.
The 5 children, B, C, D, E, and F, are for heir.
Okay, good.
In the decree of distribution settling A's estate, the court assigns lot 1 to B, lot 2 to C, lot 3 to D, lot 4 to E, and lot 5 to F.
Okay, so Katie, what's the problem here?
Well, F, if like the person, if the brother or sister
Yeah.
doesn't like them, won't let them walk.
Yeah, so F is F'd, right? It's a problem. All right, so then Katie, what happens next? What does it say?
Nothing is said in the decree about lot 5 having an easement. But
Yeah.
sometime later, F sues the owners of lots 1 through 4, claiming an easement by necessity.
Okay, so here's the tricky part, right? Poor little F, Frankie, right? Frankie gets lot 5. He gets the dump of the distribution. He gets his landlocked piece, and I think Katie predicted his brothers and sisters are a bunch of jerks, and they don't let him across the land to the road. He's stuck. He can't go anywhere. He's a prisoner of his own property, right? What happens? F sues for an easement by necessity. Here's how this works, right? Tanya, let me ask you a question, please. When A purchased lot number 1, was there any difficulty there? Was there any problem? Could it access the road okay? Well, just when A bought number 1, could A, back in the day, could A access the road okay?
Yes.
Okay. A buys lot number 2. Could he access the road okay? Okay. A buys lot number 3. Could he access the road okay?
Yep.
Okay. A buys lot number 4. Could he access the road? At that point, who owns 5? Who owns 5 at that point? Who is A buying all the land from?
He's buying it from O.
O. Now, O is not an idiot, right? O sells lot 1. Okay, so far so good. Lot 2, so far so good. Lot 3, so far so good. Tanya, what happens when O sells lot 4? What is O doing to himself?
Locking himself in.
And do we presume that people lock themselves in? No. So what do we presume O would have done when he sold lot number 4? Bingo, right? We presume an implied easement from 5 across 4, right? And we call that an easement by necessity. Why? When O purchased lot 4, not 5, when O purchased lot 4, that would have had the effect of landlocking 5. And we say that O would not be that dumb to landlock him. Maybe he is, who knows, right? But in general, we say he's not dumb enough. As a result, when 4 was purchased, an easement was guaranteed for the owner of 5 to cross 4, right? An easement appurtenant. And that way the benefit exists regardless who owns 5. Okay? Now, we know that A went ahead and purchased lot 5. Does the easement disappear? No. Right? Temporarily, the easement doesn't matter because A owns everything. You can't trespass on yourself. But the minute these 5 lots are then distributed to the children, this easement by necessity sort of resurrects, right? It comes back into force. And therefore, because 5 would be landlocked, he now has an easement to cross over 4 to get to the road. Yeah.
So if this wasn't family and it wasn't a will, and say A had sold to, I don't know, B, C, D, E, F, would that easement still be the same? Does it change the fact that it was a will?
It won't matter. It's a matter of necessity, so it doesn't really matter who's involved.
So the implied.
The important point is, while A is the owner and he owns all 5 lots, the easement basically vanishes. It doesn't have any effect.
But it still stays when they sell to E.
Instead of saying stays, resurrect is maybe a bad word, but it comes back into force, right? It resumes, because an easement by necessity exists only where it's necessary. When A owned all 5 lots, it was not necessary. But when the lots were then divided up to 5 people, it became necessary once again.
And it would stay with the property.
Yes,
only
I
if
would.
it's necessary.
Yeah, I think this is an easement appurtenant. That's how I would describe it. It's for the benefit of 5. 5 acre, if you will. Right? In any event, this is a case where it's strictly necessary. I think Morgan asked me, when is it strictly necessary? This. There's no way, I guess short of a helicopter, right, for you to get to the road other than trespassing. Even then, when you go over someone's air rights, you're trespassing something. So this is, I think, this is an easy strict necessity example. Even in Texas, I think you'd win this one. Yeah.
How would this not become a necessity when one of the edges of those properties becomes a public road, or there becomes like an appropriate?
I'm sorry, say your question again? I don't think I understood it.
So how would this not become a necessity anymore, and it would become some sort of other easement or?
You build a tunnel, I don't know.
Well, I'm just wondering, like, if 5 were to meet the appropriate amount of time, then they could do a prescriptive.
Yeah,
what
but no,
time it is.
you're not going to get to 10 years because you're trapped, right? If any of the landlords decide, I'm going to build a fence, right? Just imagine, right? You build a fence around number 5, so you can't cross anymore. You're trapped. You can't live there, right? You couldn't get to 10 years. It's not possible.
But could the necessity transfer into a prescriptive?
Sure, if you were with the proper claim of right crossing 4 every day for a decade, then you can claim prescription, at which point it's no longer dependent on necessity. But it's going to be very hard to exist on a piece of property that demands your trespassing, right? It's going to be hard to do that for a decade. If you get caught, you're stuck. You can't go home, right? Imagine that, right? Imagine you leave and then they say, oh, 4, you can't cross. Sorry, you can't cross. Can't go back to your house. You're stuck. All right. Other questions on this one? Yes, ma'am.
So, when he brings this case, like the court isn't granting necessity because it's presumed that there's already one.
Yeah, I see your question, Laura. It's a good question. The terminology is a little bit fuzzy, right? But the court would basically imply an easement by necessity, and they'll say because we presume when the original thing was chopped up, an easement reserved across 4. So it's not like you're creating it. I say implying. That's the word I like to use. But you can say whatever you want.
Would F have to pay E?
It's a good question. Sometimes when a court implies an easement, they require payment. Because this one was from sort of prior use, I don't think so. But in other cases we're going to study, there is payment that's being made. Because think about it. Now 4 got screwed, right? 4 does not fee simple anymore. He has fee simple minus the 1 stick, which requires his owner 5 to cross over. But generally, you're required to pay for the acquisition of land, whatever that's worth. But good question. Yes, sir.
So the easement by necessity only exists as long as the necessity.
That's right.
When A purchased 5, it was no longer a necessity. So it went dormant.
That's a good way of looking at dormant.
Okay,
the terminology is a
so-
little fuzzy. That's good.
So is there a time limit on the dormancy? Or is it just for the life of it, anytime a necessity
I
comes
think
up,
so. I think so.
anytime 5 sells to someone
Yeah.
other than people owning all of the other 4?
I think that's right. This is not like prescription where there's a time limit. It's a matter of equity and fairness, which is not written in stone. Make sense? Which is why it's up to the judge's discretion. There's a lot of equitable considerations that go into it. But good question.
So will we label that?
You want to just raise your hand? Yeah, thank you. Go ahead.
When we just like, let's say in an exam, we would label it or like applicant, like, would you want to use that one?
I think that would be good. I don't think this is an easement in gross. It doesn't matter who's there. I think it's for the necessity of that owner. That's why I think appurtenant's a better label. I think at least. I don't know. Questions on on this question 3. Okay. All right. Let's move on. All right. I'll move on to beach access in a minute. Any other questions on implied easements or quasi easements? All right. Yeah, Hannah.
I had a question earlier. This kind of goes like back to the necessity
Uh-huh.
requirement. Earlier you had said that a majority of jurisdictions only require reasonable necessity, but
Yeah.
in the book it says minority. So I didn't know.
Did I invert that?
Yeah, so I didn't know.
One second, let me check my notes. If I said the wrong thing, I apologize. I have majority. Did I write wrong in my notes? Is it minority? Minority? I wrote wrong in my notes. I'm sorry. Okay. I withdraw. Minority is reasonable necessity. So the Texas one, I don't think Texas rules a majority though, because I know only some states have it. They mentioned New York and Texas. I will check on that later. I'll double check later. Everyone, am I wrong on this one? This is minority? Okay, then I will stand corrected. Thank you, though. The mumbling, the muttering. I'll check after class. I'll come back to you, okay? All right. Other questions? It happens. All right, let's move on to another type of prescription, which involves beaches. They reorganized this book in a way I didn't like very much. They used to have this case about the beaches in the same chapter as the easements, but they decided to move it into a completely different chapter, which I think makes no sense. It's a chapter on public trust, which is a topic which I don't think any law professor actually wants to teach. But the concept is the same, right? It involves access to water. And there's this old doctrine known as the public trust doctrine. And the public trust doctrine says that the waters are owned by the public, right? That people cannot own the ocean. And I guess that makes a lot of sense, right? The ocean belongs to the public. But that only goes so far. How does one get to the ocean? You have to cross a beach. And what if that beach is owned by a private beach club? This case relies on certain distinctions which you may never have thought of. But I assume most of you have been to a beach. If you haven't, you know what they look like, right? So you have different parts of a beach, right? You have the ocean, right? Now, the ocean is not fixed. There's something called tide, right? You have high tide, you have low tide, where sometimes the water comes very close to the shore, and sometimes water is very far from the shore. And this is based on actually the moon. The gravity of the moon controls the tides. So sometimes, the water may be over here, and sometimes the water may be over here. Do you see on this picture that some of the sand is wet, right? And then some of the sand is dry? You know this, right? You've been to the beach, you have wet sand, and you have dry sand. And then you have vegetation, right? You have grass, right? When you're walking from the beach, you start at the water, you keep walking, you start seeing little blades of grass pop up. Then you see little palm trees, and you have actual grass, right? The further you get from the water, you have more vegetation. And the reason why should be fairly obvious. Salt water kills plants, right? You can't grow, at least plants on sand, if there's salt water nearby. All right, this distinction matters. Generally, where the vegetation line is where people can own private property, right? Generally, the private property is on the vegetation line. But then you have the dry sand, which is a little bit more tricky, which is what's at issue here, right? Does the public have an access to the dry sand? Now, that can be done in a couple different ways. One, you have the right to cross the dry sand to get to the water. And two, you have the right to actually hang out in the dry sand, to sunbathe, etc. So historically, the courts have held that you have the right to cross over the dry sand to get to the water, which makes sense, right? There will be no way of getting to the water if you can't cross the dry sand. It's impossible. And then you have the wet sand, which is basically part of the public domain, public trust, right? Because it's here today, there today. So the wet sand is basically where you have access to the public. People can walk in and out of the water, right? I mean, you can imagine you have to run across the dry sand and jump right into the water, but you can't stop, right? I guess it's kind of silly. So you have these different zones. You have the water, you have the wet sand, you have the dry sand, and then you have the vegetation line, right? Those are the different areas. And everyone at least agrees that you have what's called vertical access to go from the public street into the water. What this case concerns is not vertical access, but the horizontal, what's called lateral access, like lateral, side to side, lateral access. That's what this case concerns, the New Jersey case. And of course, since we're in New Jersey, what are they going to do? They're going to reverse the common law. You know what's going to happen, so you know how this case goes. I don't have to even describe it, but I will. All right, Katya, you want to give me the facts, please, in the first case, or the second case, I'm sorry. Matthews versus Bayhead. Improvement. Thank you. Good.
Point President instituted a suit against Borough of Bayhead, saying that they prevented Point Pleasant inhabitants from having access to the Atlantic Ocean.
Okay. And what? Just do they want vertical access or horizontal access? What?
I believe they wanted.
Okay. Again, right. This case, right, isn't just about the right to access the water. It's also concerned the sort of lateral horizontal access. Now, Katya, were there other beaches nearby that would that the people would be able to access?
Was there other beaches nearby?
Yeah.
Yeah.
Yeah, there were. I think I have a picture here, right? New Jersey has a lot of shore, right? Jersey Shore, right? You know the show. There's a lot of shore involved, and there were plenty of places, maybe a block or two away, where they could have accessed the water. Okay. Now, Tyler, what was the policy of the beach club here at issue? What was their policy?
It was kind of like a members only. If you were in the adjoining properties, that association, you were a member of the beach club, you had exclusive access to the dry sand.
Okay. Now again, do they allow people to cross over onto the beach?
Direct access, vertical access, yes.
Yeah, by the way, this is my meme from a couple of years ago. That was actually in a New Jersey Supreme Court decision, which I don't have anymore in the book, but there's a right to sunbathe and enjoy rec. Anyway, there you go. I am from Staten Island, which is, most of them were actually from Staten Island, they weren't even from New Jersey. So it's a close kinship for me. But yeah, so Tyler's right. So Tyler, the beach allowed the vertical access, they did not allow the lateral access, right?
Correct, yes, sir.
And then so what happened in the litigation?
So this public advocate on behalf.
By the way, a public advocate, I'm not exactly sure how to describe it. It's basically a person who advocates for the public. It's kind of this, it's a Jersey thing. You would understand. Yeah, go ahead.
So they said like what you said in the meme is that people had more.
Meme.
Yeah.
Yeah. Okay.
A right just
There it is.
just to access the water. They could enjoy the things incidental to full enjoyment, you know, of the beach.
Yeah, but can you tan in the water?
Lateral access. Sir?
But can you tan in the water? You're thinking too hard.
In, on, adjacent to. Yeah.
Is it easy to tan in the water?
No. Sir.
Where do you want to tan?
On the beach.
On the beach, of course, right. Yes, okay. So, yeah, so basically the court recognizes that the public trust doctrine is not limited to the vertical access, right? The right to swim also depends on the right to pass along the beaches. And it's not enough to pass. The court says you also need enjoyment of the dry sand. And there's no reason why the public trust doctrine should be different when a club, this private club, owns the dry sand. Okay? Now, we talked about the Texas case a few minutes ago with strict necessity, right? Lon, is it necessary for the people to use the dry sand to access the beach?
No.
Is it necessary for people to walk across the dry sand to access the water? No. How can they access the water? What's another way they can access the water? Well, Well, not just by boat. How can they access the water? Rob?
If they went all the way to like a public beach area.
Yeah, they walked
could
a couple
walk
blocks
through
away.
wet sand.
Yeah, they walk a couple blocks away. They get to the beach, right? I want you to contrast how the Supreme Court of Texas reviewed the necessity doctrine versus here. Here, it's not necessary at all. There are beaches on either side of this club. So necessity doesn't play a role. This is based entirely on fairness. It's also not prior use. They've never done it before. So here the court basically grants an easement, the implied easement, not based on prescription. They don't meet the time period. Not based on necessity, and not based on prior use. This is based solely on equity of how the court understands the public trust doctrine. And the court says archaic judicial responses are not an answer to a modern social problem. In New Jersey, the social problem is a bunch of people not having access to the shore to tan, I suppose. So here they extend the public trust doctrine. They mold it to meet changing conditions and needs of the public. It was created to benefit. Therefore, the public must be given access to use of privately owned lands as reasonably necessary. Everyone with me? Right? That you have both the horizontal, I feel like I'm a priest, right? You have both the vertical and the horizontal acts at the same time. I'm going to hell. I gave a talk at St. John's the other week and I cursed. I was like, sorry, Father. I once gave a talk at Ave Maria in Florida, which is a Catholic law school, and I was talking about a Supreme Court case called Morphy Frederick. And that case, you may have heard about, involved a student who held up a sign that said, "Bong hits for Jesus." Yeah, it was a student case where they had bong hits for Jesus. They were a bunch of stoner kids, right? And I was doing this lecture, I was talking about bong hits for Jesus, and there was a crucifix. I sort of looked over my shoulder. Somebody found that funny, okay. But the court holds that you have both the vertical and horizontal access to the dry sand. That's the holding of this case. Now, does this mean that you have to actually allow people to use your, say, chairs on the beach, right? Right. Let's say you have like, a beach club, and you have, chairs and towels and blankets and, different things that you allow on the dry sand. This case didn't decide that. 20 years later, the court said yes. In 2005, the New Jersey court said that all beach clubs must open the sand to the public at reasonable rates. In other words, you can't keep these people out of your club, right? You have to charge reasonable rates. And the state actually sets the rates that beach clubs can charge to include members. So basically, in New Jersey, the beaches are almost entirely open to the public, and you can't exclude people based on charging a high fee. Well, these people have a lot more money than I do now, so what do I know? Okay. All right. Questions on the Matthews case? All right. So let me summarize a bit, and I'll segue to our class next week. When you're talking about easements, you have to think of how is easement created. Last class we talked about the need to create the easement at common law. You had to attach the easement to a land transaction, and the modern rule is you do not have to do that. We also talked about licenses, which are oral, and in some cases they may not be revocable due to estoppel. Today we talked about a different kind of easement, the implied easement. You have the quasi easement, which is based on prior use, and you have the easement by necessity, which depending on the jurisdiction can either mean reasonably necessary or strictly necessary. And you also have easement by prescription, which requires you to meet the same 4 factors as adverse possession. And then finally, we have New Jersey, which is a world unto itself, in which case the beach is owned by the public, or something like that. In class for next class on Tuesday, we are going to be talking about assigning and transferring easements, which is actually fairly tricky. Okay. Anything else, Stephen?
Is this
Guys, just hang tight. Just not done yet. Almost done. Yeah.
Is it still possible to watch the makeup video class?
No, it's not. I said by Wednesday. Yeah, I said that a couple times. Yeah.
Are we getting like responses, like whether, cause I emailed saying I watched the video.
I responded. If I didn't, you can double check. But I responded and check your attendance. But I told you had a week, and that week is up. Okay. Thank you very much.